Hi, it's Alison from the Law School Toolbox. Thanks for joining us for the Second Semester ReBoot series. Let's do it. First off, missing issues and not addressing the question, because these are very, very common on 1L exams. So what's the problem? Well, one of the scariest moments when taking a law school exam is getting to the end of that fact pattern and not having a clue what you're supposed to write about. You have all this knowledge from your outline in your head, and at the moment, you've got nowhere to go with it. At this point, law students typically panic and start to do a brain dump of all the law they've learned, not really thinking about whether it's relevant or not. And they don't really address the facts in the hypo, which of course is the entire point of this exercise. Not only does this approach waste time, but it also distracts from the parts of your answer that do happen to be relevant to the question. So missing the issues and failing to address the question presented are slightly distinct problems. So let's address them separately. Now, students miss issues for a variety of reasons, but there are two that are most common. Number one, they haven't actually organized their study materials with an eye towards the exam. Outlines of this type might contain a lot of legal trivia, but no roadmaps or attack plans to help you analyze a new fact pattern, which you want to do element by element. Your study aids need to help you analyze the facts and draw reasonable conclusions, or they're useless. Second, students don't usually spend enough time reading the question and outlining their answer. If you just skim the question and immediately start writing, it's very easy to miss key details, and these details need to be informing your analysis. Additionally, the desire to, quote, answer the question and figure out what's going to happen to the parties. This can cause students to notice, but not actually discuss issues, because they just go with the one they think will be dispositive and get to the answer fastest. This is a mistake. If you notice an issue, even if it seems like a slam dunk, you always want to talk about it so you can get the associated points. Now, in addition to missing individual issues, it's pretty common for students to just not answer the question presented as it's presented. This can happen with the law brain dump that we talked about above, but it can also happen on a more granular level. Say, for example, the call of the question asks you to talk about the possible liability of Anne, Bob, and Carl. How should you organize your answer? Hopefully, you answered by the parties. So you would talk about Anne's liability, then Bob's, and then Carl's. But a lot of 1L answers would just jump into the first legal issue and start writing, and they'd jumble up the analysis of the three possible defendants. This is a mistake. If the call of the question is structured a certain way, your answer should be structured that same way. Otherwise, you haven't really addressed the question presented, and you're probably missing issues and points as a result. Similarly, if the question tells you to take on a certain role or viewpoint, it's critical to do this. For example, you might be told you're a young associate at a law firm or the clerk for a judge. Or you could be told the client wants an objective analysis of their position, or that you should provide the strongest argument on your client's behalf. If you ignore these clues to what your professor is looking for, you haven't really answered the question, and your grade is likely to suffer as a result. So, how can you avoid these errors and answer the question fully and completely, making sure you're talking about all relevant issues? Well, as we alluded to above, the answer is twofold. First, your study aids need to be prepared in such a way that they're actually helpful on an exam. We'll talk about this in a lot more detail later, but in a nutshell, ideally you want to have an attack plan for every key issue that's likely to arise on an exam. This attack plan walks you through the type of questions you'll need to ask to do a full and complete legal analysis. Second, it's critical to read the exam questions carefully, to be 100% sure you understand what you're being asked to do, and to take a few moments to outline your response on scratch paper before you start writing, to ensure you're doing what's asked and you aren't missing important details. Typically, we suggest reading the fact pattern twice, once for an overview, and once to really dig in and get all of the details. Some students like to review the call of the question, that's the part at the bottom, before reading the fact pattern. This can be effective because it allows you to read the facts with an eye towards your goal. It can also be calming because it gives you an idea of where the problem is headed before you confront it directly. So if you want to experiment with this, try it on a practice test. However, this approach doesn't necessarily help with the urge to answer the question. It's a very strong urge. Remember that a law school exam is an analysis of a problem, and that the professors are really looking to evaluate your analytical abilities. So one of the keys to not missing issues is to write about all the issues and questions that need to be answered in the analysis prior to the one you might feel is dispositive. For example, if the question focuses on whether a certain party is negligent, and is clear from the facts that the dispositive issue might be how much in damages a plaintiff should receive, you don't just skip to that part. You have to be mindful to write about duty, breach, and causation as well as harm, because these elements are part of the larger analytical framework of the negligence analysis. Remember, the goal isn't to jump to the correct answer. It's to show your work along the way. This approach will help you get maximum points by directly addressing each issue embedded in the fact pattern. You also want to ensure you're using all of the relevant facts in your answer, and unused facts can point you to issues you might need to discuss. So try underlining all the legally relevant facts as you read the fact pattern, and then cross each one off with a highlighter as you write about it. If you have a fact that's underlined but not highlighted, you know you still have things to discuss. So as you look over your exam answers, assuming you can get some, compare the issues you discussed to the sample answer. If you miss more than an occasional issue, you know this is an area to focus on for improvement. Thanks for watching, and please subscribe. Hit us up at lawschooltoolbox.com to find out more about our one-on-one tutoring help.